Good morning. Before I start, I wanted to thank my colleague Dylan Spadaccino. He assisted with the preparation of these slides. So, at the conclusion of this, if you have any questions, feel free to, talk to Dylan as well. He certainly knows this material as well as I do, if not better. But I'm here today to talk about some recent developments in alternative dispute resolution and procedure. And I thought it might be appropriate before we begin to talk about a case and some new rules implemented by the AAA to just briefly touch upon various forms of dispute resolution options available to you. I'm often surprised at the misunderstanding some of my clients have with the various options available. So let's just run through these very quickly, and I'm sure most of you know these, so I apologize in advance. The first form is negotiation, and that's fairly self-explanatory. Of course, anytime you have a dispute, you or your counsel can attempt to negotiate that dispute and resolve the situation before you proceed with litigation or arbitration. Keep in mind also that some contracts require formal negotiation before binding dispute resolution proceedings are instituted. So oftentimes there are individuals within organizations that are designated up front. For instance, the presidents of the organizations must meet and confer before anything is filed in litigation or arbitration. So be aware of your contract provisions to make sure you know what's in there. The second form is mediation. And I'm surprised by the number of folks out there that believe mediation is a binding form of dispute resolution. And that's not the case. Mediation is a non-binding form of resolution. And mediation, like arbitration, which I'll speak of, has to be agreed to by the parties. So there might be something in your contract up front, or perhaps after the projects, or throughout the project, or after the project concludes, you can certainly agree to mediate or arbitrate. But in mediation, a neutral party is selected by the parties who serves as a facilitator between the two, and essentially you meet and the mediator goes back and forth to try to reach a resolution. Importantly, most of the time up front, it's agreed to by the parties that anything said during the mediation is confidential and cannot be used in future proceedings. And this serves to try to flesh out the various issues in the case, and people can be candid with the mediator. And the mediator often will tell you his pros and cons of your case and strengths and weaknesses, and it sometimes opens your eyes, and maybe you don't have as good of a case as you think, or conversely, maybe you have a stronger case than you think. But at the conclusion of the mediation, if there is not a settlement reached, again, anything that happened during that mediation is not going to be admissible in a future proceeding. Arbitration is typically a binding type of dispute resolution. There's various forms of arbitration. Most of you probably have heard of AAA. It's the American Arbitration Association. There's JAMS. There's also private arbitration. You can pick, any attorney or engineer or architect out there to serve as an arbitrator. But again, this is typically binding. It's akin to the legal system, but instead of being in front of a judge or a jury, you're in front of an arbitrator. Typically the rules are a little more lax. It's a little more informal, but it's certainly just as important because you're typically stuck with the result that's rendered by the arbitrator. And finally, litigation, and that is during court before a judge or a jury, and I think most of you understand that. So I just wanted to touch upon that before getting into the cases, and certainly if anyone has questions or wants more detail, feel free to ask after the session, or call or email. First case we want to talk about today is Kane Builders versus Maryland CVS Pharmacy. Now, we touched upon this case last year because it was decided in 2013. We thought it was important and appropriate, however, just to give a refresher on this case because since last year's seminar, there has been no appeal, so this case is the law down in the Federal Court of Maryland. And although we're in Pennsylvania here, oftentimes other courts will look to other jurisdictions if this particular jurisdiction is silent on the issue. So in Kane, Kane was the subcontractor. The contractor was TVC Construction. And Kane and TVC entered into a standard AIA form contract as their agreement, and it was for a construction of a retail pharmacy. Throughout the project, Kane alleged that it was owed approximately $1.3 million in contract funds, and it never got paid from the general. The AIA form contract permits for mechanics lien filings. That's a remedy that the subcontractor can pursue if it's not paid. And that's just what this subcontractor did here. They didn't file a direct action against the general contractor. Instead, they filed a mechanics lien claim. The property owner of the pharmacy building was a party to this litigation. And what the property owner did here, instead of immediately challenging the merits of the case, they attempted to file, they did file a motion to dismiss. And the basis of their motion to dismiss centered upon a couple of the dispute resolution proceeding provisions in the contract between the sub and the general. Section 15.3.1 of the AIA contract states that claims, disputes, or other matters in controversy are first subject to mediation as a condition precedent to binding dispute resolution. So before you proceed, you must go through mediation. 15.3.2 provides that mediation can be filed concurrently with the other form of dispute, binding dispute resolution, so litigation or arbitration. And if that were to happen, then what happens with the litigation is it gets stayed by the judge for a certain period of time to allow the parties to engage in the mediation proceedings. If mediation proves that it didn't result in a settlement, then the litigation proceeds forward. Well, in this case, the sub only filed the mechanics lien claim. It did not file a request for mediation. So what the property owner argued is, because that condition precedent of mediation was not satisfied by the subcontractor, the underlying mechanics lien claim should be dismissed outright. So the legal question in this case is whether a mechanics lien claim is subject to section 15.3.1 of the AIA contract requiring mediation before binding dispute resolution. The court concluded that yes, indeed, 15.3.1 is sufficiently broad to include mechanics lien claims. The judge concluded that mediation was a condition precedent to the sub's right to prosecute its mechanics lien claim. So, based upon that initial holding, that's bad news for the sub. Okay, the judge said you should have went with mediation either prior to or concurrently with filing your mechanics lien claim. Fortunately for the sub, the court did not dismiss the case outright as was desired by the property owner. Instead, the court said, let's stay the case, let's put a timeout on the mechanics lien action, allow you folks to mediate the matter, and if you can't resolve the case through mediation, then we can resume the mechanics lien claim. Now, importantly, the alternative ruling would have been that the court would have dismissed the case outright. It would have been what's called without prejudice, so the sub would have still had the ability to refile its mechanics lien claim at a later time if the mediation would have proved unsuccessful. However, as most of you know, each state has strict filing requirements for mechanics lien claims. So by the time the mediation would have concluded, if it did not settle and the sub had refiled the mechanics lien claim, it certainly would have been out of time by that point. So the sub was very fortunate that the court took this approach and not the alternative approach. Practical considerations. This case serves, again, as a reminder, is we caution all of our clients. It's extremely important to know your contract. Know the provisions. People always look at payment terms. They always look at indemnification provisions, insurance requirements. Those are, some of the big items. But, oftentimes folks gloss over the dispute resolution procedures in a contract, and those can often be just as important. And as this case illustrates, this subcontractor either didn't know or perhaps ignored the mediation requirement. And as I indicated, perhaps another judge would have taken a different approach and just dismissed the case outright, in which case this sub would have lost its ability to file them or to proceed with the mechanics lien claim. So it's very important that you understand your contract, and if for some reason you don't want mediation in your contract or you don't want arbitration, try to negotiate those out. Or conversely, if you do want those types of provisions in there, try to get them in. And sometimes you're successful with contract negotiation of provisions, sometimes you're not, but at least going into the project, you know up front exactly what rules you're playing by throughout the project. Otherwise, you will be at the mercy of a court, and judges don't always give the decisions we all think they should. So that's the takeaway from that case. The second item that we want to discuss are some new rules that were developed by the AAA, and this falls in the purview of arbitration. Arbitration historically has been a preferred method of dispute resolution amongst contractors and construction attorneys. And the reason being is when you're in arbitration, your arbitrator or panel of arbitrators typically consists of either construction attorneys who do this for a living, this is what we do day in and day out, engineers or architects or contractors are on panels. Sometimes we as construction attorneys and you as contractors and folks in the construction industry are leery of judges or juries that may not know anything about construction, change orders, delays, design, and they're the ones deciding cases that, you know, there's significant money at stake. So arbitration has been favored by folks in our industry. Also, arbitration typically is viewed as being quicker and more cost efficient than litigation, which can drag on for years. Recently, however, arbitration has received some criticism because there's folks out there that believe that arbitration is turning more into litigation and it's just as lengthy and just as costly. So what's the point of going through arbitration if I'm spending just as much and it's taking just as long? In response to this criticism, the AAA developed a new set of rules which they call the Supplementary Rules for Fixed Time and Construction Arbitration. These rules are intended to let the parties know up front, you know, what the cost and the time of the arbitration will be and give them more of a ceiling for the cost that they're looking at. These are pretty fresh, so I don't have any experience with these particular rules yet, and I don't think any of my colleagues do. And again, going back to the contract, if you want these rules and you like these rules, make sure you or your attorney, when you're negotiating your contracts up front, try to get this dispute resolution in the contract. Some of the highlights, and I'm not going to go through everything, but certainly if you want a copy of the rules, let us know and we'll email, or you can go to the AAA website. They're available to the public. But some of the highlights quickly. Once you file a demand for arbitration, within 3 days, the AAA is supposed to conduct an administrative conference with the parties, okay? And all arbitrations administered under these rules are going to fall within a single arbitrator. So this does away with a panel of arbitrators. This goes to the efficiency and the cost standpoint. Certainly if you have one arbitrator instead of 3, it's going to be a lot cheaper and hopefully more efficient. Within 2 business days after the administrative conference, the parties are going to be given a list of prospective arbitrators from the AAA. And then within 2 weeks after the administrative conference, the parties have to meet and confer. That could be by phone or in person. And they are supposed to review this arbitrator list and hopefully agree upon an arbitrator, agree upon time, date, and place of hearing, number of hearing days, and some ground rules for document exchange. If the parties cannot agree upon an arbitrator, then the AAA will make an appointment of an arbitrator based upon that list. In addition, there are no post-hearing briefs permitted under these rules unless the parties agree or the arbitrator at the conclusion of the hearing deems necessary for a particular issue to be briefed. But in that case, the briefs are limited to 5 pages. So you're not going to be stuck with months of briefing of 50-page documents which are going to drive up costs. So this is, again, intended to limit the cost and make this more efficient and timely. The award by the arbitrator has to be rendered within 20 days of the close of the hearing. And also keep in mind, under these rules, it's limited to 2-party arbitrations. Okay, so if you have multiple parties, these rules are not going to apply. There is an exception that if there's 3 parties and one of those parties is a surety, and that surety is represented by the same counsel as representing the principal, then they'll allow that. But if you have multiple parties, these rules won't apply. Okay, this comes out of the rules directly, and it's going to illustrate a number of things and there's different columns for various monetary thresholds. So the second column, claims between $250,000 and $500,000. You'll see that the upfront AAA fees are $5,000. The maximum days from filing the demand for arbitration until the rendering of the award is 180 days. So by the time you file the demand, they're required to render an award within 6 months, which is pretty quick in the grand scheme of things. You know, with litigation and other types of arbitrations we've been involved in, it could be years. As you'll see across the board, there's one arbitrator allowed for no matter what the claim amount is. Maximum number of hearing days for column 2, the $250,000 to $500,000 range, there's only a maximum of 3 hearing days. Okay, so this is intended to make the parties focus in on their case, present their case and evidence in a timely and concise manner. Okay, you only have 3 days. Arbitrator compensation. There's been a lot of, I've heard a lot of attorneys criticize arbitrations because there's what they deem, you know, some of these arbitrators are making a living out of being arbitrators, and you know, it's their way of generating their own fees. So they're ordering extensive number of hearing days or extensive briefing, and that just adds to the cost that you folks might be paying in addition to your own counsel. What this is doing is capping the hourly rate at $275 an hour for this column, and it also caps the arbitration study time to 12 hours. And as you'll see, the hours in the range, you know, the higher your claim is, the more they're allotting. But under column 2, as you'll see, the maximum number, if you go the distance of 3 days and all the study time, you're looking at 15 grand, and that's typically shared between the parties, unless the arbitrator at the end awards one party or the other the arbitration fees and expenses pursuant to a contract or statute. But this chart sort of gives all parties an upfront understanding of what they're getting into from a time and cost standpoint. There's a quote from a AAA vice president, which I won't read, but you can, and they believe that, you know, this is going to make folks in the construction industry want arbitration again. And you know, for those of you that have had a jaded view of arbitration, hopefully this gives you more of an upfront understanding. But again, I must say, unless you agree to this or put this in your contract, you know, these rules won't apply. Okay, so if you want this, ask for it up front. And certainly if you have any other questions on these new rules, let us know. I'm running out of time here, but very quickly, 2 other points we wanted to make. Allegheny County this year has developed a construction court for what they call commerce and complex litigation. Judge Christine Ward has been assigned and designated as the construction court judge. Now, in federal court in some counties within Pennsylvania, when you file a piece of litigation, you typically get assigned a judge, and that judge will be your judge throughout the litigation. Allegheny County is different, as are some other counties, but in Allegheny County, you don't get assigned a judge typically. Okay, so throughout the litigation that may last years, when you're filing preliminary objections, discovery motions, summary judgment motions, you're often in front of different judges who have never seen or read about your case prior to that day. And it's from a lawyer's standpoint, it's sometimes frustrating because it's, you know, as though you're re-educating this judge, you know, every time you go in front of them for a motion or some other matter. I think that was one of the reasons they developed this court. So Judge Ward is now the point person. She's going to be handling, you know, these cases from the get-go. She's going to be handling the motions, and she's supposed to be the one handling the trial. Now, there's a number of factors that go into whether, you know, this construction law court is going to be applicable, and you can read through those. But just so you know, some of us were at a seminar recently before Judge Ward, and there is a standing order in Allegheny County that any construction litigation that exceeds $100,000, you know, that amount in controversy, is going to be assigned to this court upon a motion of a party. So if you have a construction dispute in Allegheny County, you know, either you or let your counsel know that they can get it before Judge Ward just by filing a simple motion. None of us, I believe, have had any cases that have gone to trial yet before Judge Ward, because this is new, but we do have several cases pending. I know Kurt has a trial in May before Judge Ward. It's too fresh for us to let you know our views on it, whether we think it's good or bad. Hopefully next year at this time we'll be able to offer our opinion, but so far we don't see anything wrong with it, and we hope it's going to be positive for our clients and ourselves. Again, here's some responsibilities of Judge Ward, but you can review those, and if you have any questions on this, let us know. Finally, very quickly, there was an amendment to Pennsylvania Rule of Civil Procedure 4003.5. Previously, or prior to this amendment, we as attorneys were always very concerned that our communications with experts and our sharing of draft expert reports could be discovered by the other party. So we were, like I said, concerned, and we were often guarded on what we said or what we shared. This amended rule now prohibits the discovery of attorney-expert communications, and this includes the discovery of draft expert reports. So now, we as attorneys can talk openly and exchange documents freely with the experts without fear that the other side is going to be able to obtain those communications or reports. So that's just a quick rule, more important for us than probably you, but know it's out there. And that's all I have on this topic today, and I appreciate your time. Certainly if you have any questions, let us know.